2.
My lord. Item number 2, my lord. The opposite party number 4 is the encroacher of the government land. Notice issued under Annex 1 till date he has not been evicted by Tahsildar Chandavali, OP number 3, my lord. Is not evicted, OP number 4, my lord. The representation.
Is there an eviction encroachment case started? No.
Yes.
Yes, my lord. Under Annex 1, my lord.
What's the case number?
1025 of 2012. He states that an eviction order has also been passed. That has not been annexed. Page 3, para 3.
All right. The grievance of the present petitioner is that despite an eviction order having been passed against opposite party number 4 in encroachment case number 1025 2012, the said order has not yet been executed. Notice he accepts notice for opposite parties 1 to 3. Notice to opposite party number 4 by registered speed post returnable on the next date. Paragraph before the next date, an affidavit shall be filed by the Tahsildar Chandavali explaining the status of implementation of the above order in EC number 1025 2012.
May I pray, brother? His prayer is also for disposal of the representation pursuant to that. The representation is also pending by the annexion.
And the same thing.
Yes,
it's far better than we. If no order had been passed, it's one thing. But since an order has been passed, 11 July.
Obligation.
Item number 3.
My lord, item 3 for restoration, my lord. My lord, when the matter was called out, I was not present. I was traveling from Bangalore to my lord Bhubaneswar, my lord. I also
for the reason stated, the orders recalled, the same appeal is allowed. Come to the writ appeal now.
My lord, writ appeal, my lord. Here, my lord, my issue relating to shifting of cremation center. My lord, now the authority, without taking the consent of the villagers, even though it is a Gochar land there, and the Patapur Moja, where the cremation center is to be constructed, they are already having a cremation center in plot number 887, my lord. Only to adjust, my lord, accommodate 4 persons. The entire villagers and myself is suffering. My lord, your lordship will find there is an existing, my lord, cremation center. It is observed by and the people of the locality Moja Patapur wants that it should be in plot number 887, my lord. Without, my lord, taking consent, my lord, notice was given. In the notice, it was decided that 887 will construct the cremation center. Later on, the Honorable Court said that 500 meters from plot number 870, you construct as if the Honorable single judge sitting in appeal, my lord.
No. This.
Your lordship may kindly see the
23rd August 2022, correct?
My lord.
This was the order dated 23rd August.
No, my lord, here, my lord,
No.
I have one. Yes, initially 23rd August, my lord.
Come to page 37.
My lord. My lord. To find out a suitable place, my lord. And the local people, after notice, they have stated that 887, which is near to, my lord, canal on the other side, and 300 decimals. Now, only to accommodate your
No, but somebody or the other will be aggrieved, sir. I think the learned single is right. Somebody or the other is bound to
No, my lord. Because from time immemorial, 887 plot number is being used as a crematorium. And the plot is, your lordship may kindly see page 30. Hindu Smasan. Plot number 887, Hindu Smasan, my lord, already earmarked. Nobody has raised any objection. Only to accommodate 4 persons, your lordship may kindly see the representation to the RDC by only 4 persons. For these 4 persons, entire
counsel for the appellant states that you were not a party in 14296.
No, I am not a party, my lord.
Subsequently, the earlier order dated 23rd August 2022 passed by the learned single judge. In writ petition civil 14296 of 2022 was at the instance of only 4 persons.
1, 2, 3, 4, 5 persons.
5 persons, and without notice to the present appellants. for which a representation had been made by them regarding shifting of the existing cremation ground
cremation ground,
from plot number
887.
887 to plot to 500 meters to a plot 500 meters away,
From 871.
or 871 to a plot 500 meters away. Full stop. He further submits that plot 871 was in fact earmarked.
887 is earmarked for.
In fact, plot 887 is earmarked for that purpose, and therefore there was no need to shift the cremation ground to any other place. Paragraph. You say notice returnable. July. Notice is accepted on behalf of respondents.
My lord, 1 to 3. Sarpanch and Panchayat Executive.
Yeah,
I'll
1,
take
2, and 3 by Mr. Das. Notice now to respondents 4 and 5 return by registered speed post returnable on the next date. No counter was filed in the main writ petition.
My lord, main petition, no counter was filed. In my writ application, no counter was filed. On the
Or
date of admission, it was disposed
since
of.
counsel for the appellant states that no counter affidavit was filed in WP civil number.
My lord, WP civil number 34,884.
34884 of 22, from which the present writ appeal arises. Kavash will be open to the respondents to file their respective replies before the next date. Or
My lord, I pray, my lord, stay not to, my lord. Construct
what
the-
is going to happen if it is not already constructed? Let it be. No.
Oblige, my lord.
Item number 4.
So, my lord, defect shall be removed by next day. Along with,
What's the matter about?
my
It's
lord,
a 2022 matter.
my lord, some portion of land demarcated and Tahsil defined the revenue inspector, some portion of land enclosed by co-land holder. Eviction matter, my lord. Similar matter has been disposed of. 20693 of 2018.
When is that listed?
My lord,
When is that similar matter listed?
that was, my lord, 2018 order on that was not there. Order to reflected. Last final order to reflected.
No. Have you filed a representation?
No.
No,
Why didn't you make a representation?
representation demarcated final manual by WBC number. That 33730 of 2022 demarcate by this writ application demarcated was made.
I'm not able to understand
His
anything.
case is, my lord, demarcation was done in presence of the RI and the Tahsildar.
Tahsildar.
And the report says that 600 feet of land has been enclosed by the private opposite party. He has made a representation, but that has not been annexed. And para 6, he has taken an amendment. Para 6, he has said that he has approached the Tahsildar, but he is not taking any action. He has not approached in the sense he has not.
Where is a copy of the representation? You approached Tahsildar meaning what? Para 6 comes to para 6.
My lord. My lord.
So the petitioner made an approach to the Tahsildar.
As well as to the IIC.
Where is that?
Not annexed, my lord.
Ah.
Unfortunately, I will not annexed, my lord. This is 15/5/2020.
20.
20.
And you are coming in 23, 22.
22.
You make a fresh representation. You see, it appears that the previous representation made by the petitioner to the Tahsildar was on 15th May 2020, nearly 3 years ago. So consequently, the court permits the petitioner to make a fresh representation to the Tahsildar with his grievance. And after following up with such representation, to seek appropriate remedies in accordance with law. The writ petition is disposed of in the amount.
Oblige.
Item number 5.
Please, my lord. My lord, here, this is a PIL, whereas my lord, one private person also possessing the government land, that is creating hindrance to the public road, whereas an emergency vehicle could not enter into the village, as well as the school students, they could not came out and get into the village. So we have filed a representation for the collector. Let the collector take a decision.
Where is that proof of making the representation?
Annexure 4, 3, 4, 5.
No. Where is the proof?
Because they are not given in acknowledgement, no.
No, they will always give an acknowledgement.
Marathan, I'll file a fresh representation again.
Yeah.
For sure.
Counsel to the appellant, petitioner seeks leave to withdraw the present petition with liberty to file a fresh representation to the authorities and after following up with such a representation to seek appropriate remedies in accordance with law. The petition is disposed of the amount terms.
Item number 6.
Item number 6, permitted to withdraw, my lord.
All right, dismissed as withdrawn.
Item 7.
May I please, Lordship? Lordship, the petitioner is in possession of a certain land which is reflected in Annexure 1, Lordship, and a public road which is being used as the approach road to the main road by this petitioner and other villagers, Lordship. But in the meantime, opposite party number 3, along with some other villagers have encroached the aforesaid
All right,
public
you see
road.
the petitioner's representation, bracket annexure 3, will be examined by the collector Baleshwar and after notice to the petitioner and opposite party number 3 and are giving them a hearing. A reasoned order shall be passed not later than 1st July 2023 and be communicated to the parties within a week thereafter. The court clarifies it is not expressed in the matter.
Oblige, Lordship.
Item number 8. Item number 8.
Unmute, sir. Please unmute.
Please, your lordship, I am on visit due to my leg problem. The petitioner filed this writ petition. My lord, the petitioner filed this writ petition for eviction of the unauthorized encroachers, my lord, 4 to 6. My lord, the petitioner filed this writ petition for eviction.
So please come to page 16, 16.
16 is my representation, but prior to this, your lordship tried to have a glance to page 15. Page 15, annexure 3, my lord. The Tahsildar have directed the Amin for demarcation of the land. But since
Demarcation is different, sir. Page 16.
I have filed a representation to the Tahsildar for eviction of the unauthorized encroachers.
Kindly show us proof. Kindly show us proof of submission of representation.
My lord, I beg to submit that on the basis of my grievance petition, the RI had annexure 15 has inquired into.
No, that is not correct, sir. What is it? Annexure 15. Give me the date of that document. Annexure 15 date.
21 July 2022, my lord. The representation filed with Tahsildar on the basis of which he has directed the
No. Kindly come to the date of page 15.
My lord. Page 15. Page 15. Page 15, my lord.
Date, please. Date of annexure 3.
Annex 3, 22/10/2022. 20, my lord.
20, sir. Now come to the date of the next page.
My lord, thereafter they are taking process, my lord. They are taking process, but not yet evicted. Thereafter, I compelled to file this representation on 20th, 1st July 2022, my lord.
Now listen to the question carefully, sir.
My lord,
Please listen to the question carefully.
my lord, they have encroached the
Kindly
government.
listen to the question carefully.
My lord,
Are
Honorable
you
Supreme
prepared to
Court,
listen to the question?
my lord, Honorable Supreme Court specifically directed.
Sir, please listen. Please hold on for a moment and listen.
My lord,
What is, ask him to show proof of submission of representation at page 16.
Where is the proof of submission of the petition?
That is my 21.
No, sir. No, sir. It is the date. You giving picture, 2nd July. But
My lord, the petition filed to the Tahsildar directly because they are local people.
no. You see,
My lord,
the petitioner raised representation to the Tahsildar, and after following up on such representation to seek appropriate remedies in accordance with law, the petition is disposed of. Item number 9.
The petitioner has a limited prior before lordship. Annex 3 is pending before the opposite part number 2. The opposite part number 4 to 8 are encroacher to the Austrian government land when this is a passage across in case of the petitioner's lands. So I made a different representation before the opposite part number 2.
Same question, sir.
Milord.
Is there a proof?
That was page 18.
18, all right.
18, all right.
The petitioner's representation, bracket Annex 3 series, will be examined by the Tahsildar Bhadrak and after notice to the petitioner and opposite parties 4 to 8, and after giving them a hearing, a reasoned order shall be passed. Not later than 15 July, may be communicated to the parties within a week thereafter. The court clarifies it is not expressed in the matter.
Okay. Item number 10. Item 10.
And we put down is, he said, after the petitioner's representations, bracket Annex 4, shall be examined by the Tahsildar Derabish Tahsil. And after notice to the petitioners and opposite party number 4, and after giving them a hearing, a reasoned order shall be passed not later than 15 July and be communicated to the parties within a week thereafter.
Item number 11.
Lordship, kindly pass over.
Right. This is state of Odisha, sir.
Yes, declaration of DLR employment on 25th of April, Lordship has kept the.
25th April. Right.
Item 12. I am for the appellant, my lord. Kindly see for a moment page 49, my lord. The petition was
Delay. All right. Yes.
kindly see, my lord, page 49. The appellant was challenged the order of my lord, kindly see. The Lord and Honorable Singular has granted, has allowed my read and granted, my lord, kindly see the benefit for the aforesaid discussion and reasons. The impugned order passed by the opposite party number 3 stands quashed, and the opposite party number 3 hereby directed to pass necessary order of approval of service of the petitioner and extend the benefits of granting it in the light of and as provided to said Devendranath Mishra under GIA 1991 or others within further. Thereafter, they have the government has complied, but the benefit was granted from the date of order passed by the Honorable Single Judge. Thereafter, I challenge the same. I paid the arrear salary and granted it.
You've been relegated to the Odisha Education Act.
Well, my lord, but the Honorable Single Judge has said that since there is a provision
under the Education Act,
I have to challenge in Odisha Education Tribunal.
Right.
My ground of challenge that since by virtue of order of this honorable court, the benefit has been accrued in my favor.
Thereafter, can follow it.
My lord, thereafter in a similar case, I have enclosed the judgment of my honorable same thing judge, my lord, has passed, my lord.
When was that passed?
My lord, kindly see for a moment only one paragraph, my lord.
When was that passed, sir? What was the date of that matter?
In other identical cases.
Date, sir.
11/4/2014.
How many years before? How many years before this impugned order?
My lord, there were 6, 7
years. So don't.
Well, kindly see for a moment. For a moment, kindly see the.
Not necessary, sir. Not necessary.
Go only one paragraph. Only one paragraph.
Right.
May I read, my lord? Page 72, relevant. The impugned order has resulted in denial of the fruits of the orders which were passed in favor of the petitioners in Annexure 11, which has been acted upon. Denial of the same at a subsequent stage without any rhyme and reason is hit by the principle of estoppel. Therefore, in such circumstances, in the name of fresh cause of action pursuant to impugned order to push the petitioner again to file OA challenging the so-called order passed by the respondent in disposing of the representation would be a travesty of justice. Therefore, even though the forum is available to challenge the impugned order by approaching tribunal in the name of fresh cause of action, this court is not inclined to relegate the petitioner to approach the Odisha Administrative Tribunal to assail a wrong order while disposing the representation in compliance to the order passed by this court in WBC number such on hence the writ petition is maintainable.
Or you say the petitioners, the appellant is aggrieved by the impugned order dated 2nd July 2021, passed by the learned single judge, disposing of the appellant's WP Civil 16375/2021 on the short ground that the learned single judge ought not to have relegated the appellant to the remedy under section 24 capital B of the Odisha Education Act and the rules framed thereunder for implementation of earlier orders in his favor passed by the learned single judge in separate writ petitions. Paragraph, having heard learned counsel for the appellant, the court is not satisfied that any error has been committed by the learned single judge in relegating the appellant to the alternate remedy mentioned herein before. The writ appeal is accordingly dismissed.
Item number 13.
Item number 13, my lord.
13, that order may be recalled, this order may be passed.
All right.
I am giving
13 matters, only thing matters may I point out. Well, pendency of this appeal, I have been acquitted of criminal charges matters prior to that matters in departmental proceeding. Only thing is that my lords be pleased to observe, the same order may be passed, please to observe that to open the seal cover.
I have corrected that only numbers I have corrected.
All right, same order. The IAs that order is recalled and writ appeal is restored to file. In the writ appeal, you said today this writ appeal has been restored by virtue of the order dated passed today in IA number 1985/2023 and then pass this order.
May I renew my prayer manners. Only the seal cover procedure has been followed. My lords be pleased to dispose of direct matters to consider and
single judge
pass an appropriate order. That will suffice the justice because petitioner is retired in the meanwhile.
That's all. Same orders. Same. Right.
Item number 14. In 14, similar orders will also passed, but that has been fixed to 24th. You will also keep it to 24th. I have given that copy, my lord.
24th April.
My lord. Right. Item number 15.
Simply say list on 24th.
Yes, that I am submitting because item 15. Item 15 will also fix it to 25th.
25th April. All right.
Item 16 also 25th.
All right.
Item 17, 17. Item number 17. Yes. Sorry. Here, this is a case, regularization ambulance drivers who are continuing on the ARC case. That is a Rogi Kalyana Samiti. The Honorable Single Judge had directed for regularization.
No. Is there similar matters?
No, my first time it is coming. So, ambulance drivers, Rogi Kalyan Samiti, no, that's a Samiti. Relying the judgment of Uma Devi, Honorable Single Judge had directed for regularization.
First day.
First day, also that's the first day.
No counter, nothing.
Nothing.
All right. Notice returnable. July. There should be stay of the impugned order till then. All right.
Item number 18. Item 18 of 14th September. What says?
All right. 14th September.
Item 19. Job contract 14th September.
14th September.
19, 20, 21 and 22. Item 23. 23, my lord, promotion during pendency of vigilance case, 11th May. Item 24. 24, 25, 26, 14th September.
All right.
Item 27.
May I please your lordship, I am on virtual mode. Item 27 in this writ appeal, my only prayer is for notification of the learned single judge order, in which your lordship may kindly see the annexure 1, page 8, 9 and 10, which is the running page of the order of the learned single judge, in which the learned single judge has directed the appellant to consider the representation of the petitioner and to give him his great pay. But your lordship, we are agreeing with that. My only prayer is he has to apply in a prescribed format as per the AICTE norms. Your lordship, that prescribed format is that your lordship may kindly see.
Sir, you were to implement this order when this is 27th September 2022, correct? This order was passed on 27th September 2022.
Yes, your lordship. Yes, your
It
lordship.
should have been implemented by today.
Your lordship, in between we have lordship, actually he has to provide in the prescribed format. After that we will consider. He has only given a handwritten representation, your lordship.
So what, sir? What is the
As
problem?
per
You could
the-
have told him, apply the prescribed format.
Yes, your lordship, we have given a lot of letters to him.
So why should we interfere in this kind of matter? This is not a matter to interfere at all.
Your lordship, we
Having
have
heard
only-
learned counsel for the appellant and having perused the impugned order of the learned single judge, the court is of the view that it calls for no interference whatsoever. The writ appeal is dismissed.
Item 28, 2010-29 work charge employee 14 September.
Right.
Item 30. Yeah. Item number 30.
None appears dismissed.
Item number 31. 31 by 14 September work charge employee.
All right.
Item 32.
My item 32 and 33, 14th September.
All right.
Item 34.
Yes. 34 mal similar matter as in thick. To 12th July 2023.
Right. Same.
Item 35.
35 my rehabilitation 30th August.
August.
Item 36. 8th of May, my lord.
Right.
Item 37. 37, my lord, 11th of May, my lord, promotion during pendency of vigilance post.
All right.
Item number 38.
May I please your lordship? When I am on history matter.
Yes.
Here, the petitioner is a legacy under a will minor. He got property, two sets of property through two wills minor. That is under Annexure 1 and that is another is Annexure 2. Annexure 1 is of dated 19/2/2008. Annexure 2 is of date 7/5/2008 minor. Then subsequently.
So this is exercise of jurisdiction under Article 227, correct?
Minor.
The impugned order
Minor.
is an exercise of the jurisdiction under Article 227 of the Constitution, correct?
Minor. Both 226 and 227 because
No. This is 227, sir.
the impugned order is not passed by the civil court minor.
And after all, it's only a remand to the additional commissioner.
Yes, minor.
That's all right. No harm is caused to anybody, sir. There are two difficulties as far as the present writ appeal is concerned, which is directed against an order dated 17th May 2022, passed by the learned single judge, disposing of writ petition civil 1447 of 2016. Filed by respondents 1 and 2. First is that the impugned order appears to have been passed in exercise in the jurisdiction of the learned single judge under Article 227 of the Constitution, and therefore the writ appeal may not be maintainable as such by virtue of the decision of this court in Mohammed Saud versus Dr. Major Sheikh Mahfouz, 2008 to OLR FB 725, which has been affirmed by the Supreme Court in 2010, that citation paragraph. The second, even on merits, the court finds that the impugned order merely relegates the parties to the Additional Commissioner Settlement and Consolidation Sambalpur for a fresh adjudication of the revision petition. after giving an opportunity of hearing to all the parties. No prejudice can be said to cause the present appellants on that score. For the aforementioned reasons, the court finds no merit in the present writ appeal. It is dismissed. Obviously, sir, it is obvious that all points available to all the parties can be raised in the fresh hearing in the revision petition.
Item 39. 14th of September, my lord, job.
Right.
Item number 40. 40 rehabilitation assistance scheme, my lord,
30th August.
Item number 41.
41 was job contract 14th September.
14th September.
Item 42. Item number 42.
None appears dismissed.
Item number 43.
43 was rehabilitation 30th August.
All right.
Item number 44.
May I challenge the order of single judge, my lord, on the ground that though in para 4, page 24 in the writ application, the petitioner explained the delay of filing the writ application. The learned court held that the petitioner has not explained the delay, my lord. Page 24, my lord. Running page 24. Page 4, my lord. In the original revision, the petitioner was not party in this case. Without making the petitioner as a party, the opposite party filed the revision and get the order. Thereafter, the petitioner.
No, but 24th September, opposite party number 9 informed you.
My lord. My lord, thereafter, opposite, in case the area.
So from 24th September 2019, you became aware.
My lord,
But you filed the writ petition only in 2020. When was that?
My lord, thereafter the petitioner approached the Tahsildar, my lord. Tahsildar and last part, Balyanta rejected the miscase on by the order dated 13/1/20, my lord. Thereafter the petitioner filed the writ application in the year 20, my lord.
What was the date of filing the writ petition?
My lord, date of file
16/3/2020.
My lord, 16/20, my lord. Rejected 13/1/20.
Okay.
My lord.
All right. You say counsel for the appellant points out that in paras 4 and 5 of the writ petition, an explanation was offered by the appellant for not filing the writ petition earlier than 16 March 2020. And that the said petition was filed only after first approaching the Tahsildar Balyanta with miscase number 107 of 2019, which was rejected on 13 January 2020 by the Tahsildar. Paragraph. Notice returnable. July 19. Notice is accepted by opposite so and so Mr. Das for respondents 1 and 2. Notice to the remaining respondents by registered post. Returnable on the next date.
Item 45.
Pardon to mention, my lord. I'm sorry, little bit late, my lord. Item 42, I was the caveator.
Caveator.
Yeah.
All right. Just say, what is the order passed in that? They put down his name. All right.
A copy may be sought by the lawsuit direction may be issued to
Dismiss the non-prosecution, sir.
He's saying the wrong number.
Item 40.
He's at 30. Sorry, man. Sorry.
Item 40.
I'm sorry. I'm sorry. I'm horrible, my lord. I'm sorry.
All right. You give him a copy.
My lord. Item number 45.
45 my sir, 8th May.
46. My lord, work charge April 14th of September.
All right.
47, 46, 47, 48. Same.
Right.
Item number 49.
My lords, condemnation delay petition is ready. I'm filing it today in course of the day. And the connected matter, your lordship sees at the judgment of the Honorable Single Judge at page 19. The first matter has not come up before your lordship. So what I pray humbly before your lordship, let that come along with this. And today I'm filing the condemnation petition also as per your lordship's convenience.
What is the other connected matter?
So connected matter at page 19, your lordship sees
No, there is a writ appeal filed.
Writ appeal.
Give us the number of the writ appeal.
381, my lords. Writ appeal 381 of 2023.
Okay, list along with 381 of 2023 on 3rd July.
I don't know, 40, 50.
My pleasure. This is a matter regarding allotment of a commercial B category commercial plot in sector 13 of CDA. The petitioner applied for commercial plot. His case was considered, and ultimately it is found that in the lottery he is not successful. Therefore, no allotment was made in his favor. That order was challenged before the single judge, and the initial deposit which has paid at the time of application, that was also refunded to him after the selection was over. Now his case was considered, and it is found that the CDI authority has done correctly, lottery was correctly done, and everything has been done correctly, and therefore his petition was dismissed. With the observation that the initial deposit he has made, that is to be refunded with 8% interest thereon throughout from the date of the petitioners. Now, as soon as we have refunded the amount along with a check, he has received the check, kept with himself, did not submit the before the bank. Now, for the first time, at the time of hearing, he is
All right. Counsel for the appellant points out that the initial amount of rupees 1,50,000 deposited by the respondent was in fact refunded to him by way of a check issued way back on
2008.
Date
17/12/2008.
17/12/2008. But the respondent chose not to deposit it in his bank, and therefore it remained unencashed. Full stop. By the impugned order, the same amount has been asked to be paid by the learned single judge, directing the appellant to repay it to the respondent with simple interest at 8% per annum for the entire period till the date of payment, which is notice confined to the above issue, returnable 19 July till the next date. The aforementioned direction in the impugned order shall remain state.
Obliged.
Item 51. 51, my lord, on behalf of Mr. Rao, not today. He is out of station. Requested me on morning, my lord. Today morning, he requested me over telephone to make a prayer before my lord.
Matter about
Not today, next week. He is out of station.
what's the delay, sir?
Delay as per my senior's calculation is 20 days.
Sorry?
Delay as per his calculation is 20 days now.
Answer for the appellant statements of some difficulty. Based on 27 July.
Item not 52. I have 52, 53, 54, 55, and 56. Sartapada 8th May. Item 57,
14th of September, my lord, job contract.
Right.
Item 58, 8th of May, my lord, Sattapad.
Right.
Item 59, 59, 60, 61, my lord, job contract, 14th of September. Item 62,
As 62, my lord, Honorable Single Judge has disposed of the matter in light of another case, my lord, that has no nexus with this case, but that relates to certain categories of persons. They have approached the industrial tribunal and award was passed in their case. Accordingly, they were allowed the differential scale. So this case is quite different from that, covering that case that Honorable Single Judge has directed to disperse there. Page 14 is the impugned order.
All right, you say notice returnable. 1st August. There should be a stay of the impugned order to that.
Item 63, my 63, 64, 65, job contract 14th September.
Right,
Item 66, my rehabilitation 30th August.
right.
67, promotion during pendency of criminal case 11th May.
11th May,
Item 68, rehabilitation 30th August.
30th August.
Item number 69, 69, 70 and 71 about 14th of September, job contract.
Right,
Item number 72,
72, my rehabilitation assistant 30th August.
item 73,
73, 74, job contract number 14th September.
right.
item number 75, 75 rehabilitation assistant minute 30th of 38 minute. Item number 76, 76 is the data entry operator minute outsourcing. That is
8th August.
8th August minute.
Right.
Item 77, minute regulation matter minute 25th of April. Item number 78,
My 78, 79, 80 and 81, job contract 14th September.
अच्छा हाँ ठीक है इसमें सब पहुंच गया supplementary list fresh admission item number 1 ARBP 81 of 2022.
May I please, your lordship? Matter, lordship, we are challenging the order of the learned arbitration appellate tribunal to the National Stock Exchange, lordship. That order, first we have asked for enhanced amount, but the learned tribunal has passed the amount which is not satisfactory to me. That's why I challenge this matter, lordship.
No, 34, why is a section 34 petition coming here?
Lordship, this is a case.
No, 1 minute. Section 34, they are not dealing with section 34 arbitration, only 11. List before the roster bench. This is a petition under section 34 of the Arbitration Conciliation Act 1996. List before the roster bench. On 26th April.
26th April, lordship. Lordship, I have some difficulty. In 26th April, lordship, my college matter 1st of May. I have some difficulty. They have to.
All right, 1st May. All right.
Item number 2.
This should be not ARBP then. No? This is section 34. Section 34 is not numbered as ARBP. ARBA. This is a petition under section 34. So it should be therefore registered as an ARBA and listed before the roster bench. All right.
Item number 2, sir. May I please, your lordship? The arbitration clause is there, my lord. Petitioner has paid for appointment of arbitrator, my lord.
All right. The notice returnable. (19th May).
Obliged. Item number 3.
My humble prayer before Lord for appointment of arbitrator under section 11.
All right. Say notice returnable 19th May. All right.
Okay.
Item number
You
4.
accept for state of Odisha?
Yes, my lord.
He accepts for state of Odisha. And states that he will obtain instructions or file an affidavit before the next step. All right.
Item number 5.
Well, it's item 4. Please, your lordship.
That was 4.
That was 4. No.
That was
What are
3.
you saying, sir?
Item 4, sir.
That's item 4, page 13 is the arbitration clause.
All right. Notice returnable 19th May.
Grateful.
Item number 5.
pass over.
Item number 6.
11-6 malus, appointment arbitrator malus.
Notice
And-
returnable 19.
Malus.
All right.
I'll solve the
Same for
copies.
7, 8,
No, this
7
is
and 8 also.
malus. State copy, I'll solve malus.
Yes.
Not because not necessary. malus.
Accepted by, you appear for the respondent.
Yes, malus.
Accepts and states that he'll either file an affidavit or obtain instructions.
Only 2 notice. Notice will go to only 2. Rest I'll solve the opposite on 2. 2 minus I'll solve, I'll send notice.
All right, he accepts the respondent, opposite party number 2, notice to the remaining.
No, yes, malus. No, 2 notice should go. And 1,
So
3
you're
and
not
4.
clear in what you're saying, so 1 minute. Just let me just
Item
see.
6.
All right, item 6 malus.
There are 4 respondents.
Yes, malus.
Ah,
5 malus.
so what are you saying, sir? Arbitration petition 22 of 2023 are appearing.
21 malus.
You're not in 22.
22 also I'm there.
All
21,
right.
21, 22, 23. In 21, there are 5. In 22,
1 minute, 1 minute, sir. One
malus.
minute. In 21, there are 5.
Months.
You are appearing for 1, is it?
Yes, 1, 3, 4, and 5. State.
He accepts notice for 1, 3, 4, and 5. Notice to the respondent number 2,
Malus.
returnable on the next date. Then you give a longer date. Returnable 30th June,
Malus.
30 June.
Malus.
Then in 21, 22,
Malus.
there are only 4.
4.
Yes.
In 22, you say accepts for
2, 3, 4.
2, 3, and 4.
Malus.
Notice to respond number 1, returnable on the same day. And then
Then next also 2, 3, 4.
23 also.
Malus.
2,
Yes,
3, and
2,
4.
3, 4.
2,
All
3.
right, all right, all right.
But Lordship is fixing a date for it.
30th June.
32.
Item number 9.
Obligations.
Lords, I am appearing through VC, Lords. It's also
Yes.
an application for appointment of arbitrator. The arbitration clause is at page number 22, Lords.
All right, notice returnable 23rd June.
Grateful.
Item number 10.
My lords, notice was issued. The opposite parties had taken time to file counter. Last order, your lordship will see.
She's appearing.
Mr. S.S. Manti.
My lord will be filing immediately in the course of the day today.
All right, counsel for the opposite parties shows that the counter will be filed during the course of the day, rejoined for the next date. 30th June, 30 June.
Item number 11.
I have already received the Paravise, my lord. Only 1 week time, man. On the last occasion, I have taken, only last time I have only taken time.
Counsel for the respondent Union of India assures the court that the counter affidavit will be filed
Within a week.
not later than 5th May 2023. List on 23rd June. Rejoined for the next date, 23rd June.
Next item is same.
Item 13.
My lord, kindly allow a passover.
All right.
Item number 14.
My lord, I am for the petition from virtual mode, my lord. My lord, the arbitration clause is at page 20, my lord.
Your lordship, today I am filing counter. I have a copy of my lord's seal.
What are you saying in the counter?
Only 12.5 is the issue.
Sorry?
Section 12.5. The
My lord, in the
departmental arbitration.
This obviously that can't.
My
So
lord.
you say the only stand taken in the counter affidavit filed by the opposite party is that they have an in-house arbitration provided under the clause 3 bracket 2 of the agreement.
Not similar order has been passed.
That order,
Lords have passed.
In every
that
circumstance.
clause cannot survive after the amendment to the Arbitration Conciliation Act in 2015. What's the, will have the same arbitrator? Accordingly, the disputes are referred for arbitration, or including claims and counterclaims. Accordingly, the court appoints Justice S.C. Parija, a former judge of this court, as sole arbitrator. The arbitration will take place under the aegis of the arbitration set.
My lord.
Item 15.
15, Lordship. Last.
Unclaimed.
Yes, my lord.
It's come back unclaimed. What does that mean?
That means
Served or not served?
My lords, in 15.
You are there. 15.
My lords, we have filed Wakala today, my lords. Counter filing on Monday.
All right. Counsel for the respondent states that they'll be filing the counter affidavit within 2 weeks. List on 23rd June.
short date, my lord, because
Vacation is there, sir, 1 month. When will you file your reply?
So on Monday, my lords.
On Monday?
My lords.
Oh, I see. States that he'll file his reply within a week. List on 12th May.
much best.
Great, my lords.
All right.
My lord, item 5.
Pastoral matter, item 5.
Item 5.
Item 5. please.
Again. My lord, may I kindly appointed arbitrator.
Notice has to go, sir, first.
My lord.
Notice returnable 23rd June. All right.
Obliged.
Pastoral matter, item 13.
My lords, item 13, my lords. My lords, this honorable court was pleased to refer the matter to mediation, my lords. My lords, the matter is going to
Mediation
be
report is there. 1 minute. Let me just see. Further mediation. All right. Mediation is in progress. List on 7 July.
great for my lords.
Over.
Specialist. Specialist. Trace admission item number 1.
None of this.
Item number 2.
No instructions. Okay. Item 1, no instructions.
Item number 2.
None of this.
Item number 3.
None of this.
Item number 4.
None of this.
Item number 5.
Same order.
Item 6.
Here, my lords, I am challenging the initiation of the proceeding under the PWDB Act. Lords, on the ground that on the self-same allegation, my lords, one GR case has been registered and which has been ended in acquittal. Lords, I have filed the certified copy of the judgment in the GR case, that is at Annexure 2, my lords. Lords, this is a sheer abuse of process of law, my lords.
No, but wasn't an appeal filed against that judgment?
No, that, lords, against the GR case, my lords.
Yes.
That I don't have an instruction. Lords, lords,
Find
will
out.
take it up next week. I'll take.
All right. At the request of Clerk Counsel, the petitioner who wants to ascertain if any appeal was filed against the judgment dated 1st December 2018.
Item 9.
437 surplus 6 years, this appeal was rejected by the trial court, my lord. The trial is not concluded within 60 days for the first taking of evidence, my lord. Charge was framed on 12/7/2018.
Bail application. You can always renew bail, sir. Why all this tortuous route?
Well, Lordship can see
You
charge.
can always renew your bail. This is a 2019 order.
Yes, ma'am.
And we're in
Till
2023.
not concluded, my trial. Till then
No,
not
you see, you apply for bail again. You apply in that court again.
That's my observe, my lord.
Counsel for the petitioner states that the petitioner will apply to the trial court again for bail in view of the changed circumstances and passage of time. It is clarified that the impugned order will not come in the way of an independent consideration of such bail application by the trial court as and when filed. The petition is disposed of the above sections.
Item number 10.
Item number 4, my lord.
Tell us.
That not pressed, your lordship.
All
That the trial has been going to be complete.
All right, dismissed is not pressed.
Not pressed, my lord. Not
That's
pressed.
right.
But item 10, madam, compromise question.
All right, counsel for the opposite party number 2, informant, states that stands by the affidavit filed by the informant stating that all disputes have been settled between the parties and both are staying together. Full stop. That leaves the matter take from the break clause and all proceedings consequent thereto are hereby quashed.
Well,
Item 11.
None appears dismissed.
Item number 12.
My lord, item number 12, my lords, I am permitted to withdraw to file a fresh, on fresh cause of action. My lord.
So all that's counsel for the petitioner seeks leave to withdraw the present petition with liberty to seek appropriate remedies.
Obliged.
If any fresh course of action arises, disposal of withdrawn with liberty as paid for.
Item number 13.
None appears dismissed.
No instruction. My lord.
No instruction dismissed.
Item 14.
None appears dismissed.
Item number 15.
May I please? One of the petitioners are the father and mother of the principal accused, Vishwajit Naik.
You are there in this matter.
I have no objection, my lord. I am for the opinion number 2 and 3, informant and victim, my lord. The main principal accused has already expired.
Counsel for the opposite party 2 and 3 informs the court that the principal accused is already expired and that he has no objection to the prayer made by petitioners 1 and 2. That view of the matter take from the prayer clause and all proceedings consequent that were hereby quashed.
Item number 16.
Passing of criminal proceeding on the ground of decree of divorce. Already opposite party already received the permanent alimony of rupees 3,50,000. Archive kindly see the page 23 on page 23.
Counsel to the petitioner states that pursuant to the divorce granted, dissolving the marriage between the petitioner number 1 and opposite party number 2, the complete alimony, the full alimony amount has been paid and no dispute survives. Notice returnable before the roster bench on 4th July.
Item 17.
None appears dismissed.
Item number 18.
Same order.
In item 18, I have challenged an order attachment of my properties under the OPID Act. What has happened is, in the meanwhile, a bench of this honorable court has held that a CRLMC or CRLA is not maintainable. It could be a civil appeal. So I have filed an IA for conversion of the CRLMC into a civil appeal, but that has not come on record. So may I pray, let it be listed before the appropriate bench for conversion.
All right. Counsel for the Mr. Devashish Pandal and counsel for the petitioner points out that an application has to be filed by the petitioner, has been filed for the petitioner for converting the present petition into a civil appeal. The matter along with the said application be placed before the roster bench on 15th May.
Obliged.
Item number 19.
None appears.
Item 20.
Same order.
21.
Same order.
Item number 22.
Same order.
23.
Same order.
Item 24.
May I please lodge? The petitioner here is the husband and the informant by way of a marriage card which is forged and without being married to the petitioner number 1 has lodged a 498A FIR. My lord, just the fact is the husband was already married. He was going through a divorce proceeding during that time. The father of the informant insisted his daughter's marriage to the petitioner's family. Again and again. There was no taking of divorce. There was taking of divorce. How could he marry? And then he has been going through, his entire family has been going through this criminal proceeding without being married.
All right. You point out to the court below, permitting the petitioner to raise all pleas in the appropriate stage.
Obligation.
Item number 25.
None appears.
26.
Same order.
Item 27.
Same order.
Item number 28.
Same order.
Item number 29.
Same order.
Item 30.
Same order.
31.
Same order.
32.
May challenging the entire criminal proceeding on the ground, my lord, the FIR laws in the year 2011. Since last 12 years, my lord, Till date, my lord, charge sheet has not been filed.
That's because they will be telling that court this is pending.
My lord, for that reason, your lordship has directed to file a counter, my lord, and the affidavit filed by the inspector, my lord.
This is human trafficking, sir.
My lord, no, he has filed 2 FIR, my lord.
Yes.
The informant file has 2 FIR that the husband of the petitioner, husband of the informant was kidnapped by the villagers, my lord. In the connected case, my lord, trial was commenced. And in the trial, my lord, he has deposed different thing, my lord. My humble submission, my lord, see if any mishap in the meantime, my lord, happen, my lord, the present petitioner is responsible for that, my lord. She has hired her husband and the investigating officer, my lord. Your lordship can have a glance to, my lord. The informant is not cooperating. Your lordship can have a glance to paragraph 4 of the affidavit, my lord. The informant herself is not cooperating.
Then what's the problem?
My lord, for the last 12 years,
no time then.
my lord, for the last 12 years, democracy showed is
because you have filed this petition is not moving on. The understanding is if some 482 is filed, everything comes to a halt.
No, my lord.
Yes.
In this case,
This is what I've been watching everywhere.
No, in this case, there is no step in
Exactly, but doesn't matter. Your counterpart, are you appearing in the trial court? No. Somebody else is appearing. You must be telling that court.
He has filed 2 cases in between 2 months, my lord. In the first case, trial commenced, my lord. And second case, my lord, since
now it proceeds. You say permitting the petitioner to raise all pleas at the appropriate stage.
My lord, your lordship, my humble submission, my lord. Your lordship may kindly direct the conflict investigation.
No, it's all right. Yes.
Item 33.
None of this dismissed.
34.
No instruction.
No instructions dismissed.
Item 35.
The matter become infectious.
All right. Dismissed as infractious. All right. The memo is taken on record.
Item number 36.
May please, your lordship. My lord, on behalf of Rajiv Luchan Patnaik, item 36 and 54 permitted to withdraw.
All right. Memo taken on record, dismisses, withdrawn. All right.
Obligement.
Item 37.
None appears dismissed.
Item 38.
38, there are no instructions, my lords.
All right.
Withdraw.
All right. Dismissed is withdrawn. Right.
Item 39.
In 39, the petitioner has died, my lord. So it has.
All right. Petitioner has died. Dismissed as having abated. All right.
Item 40.
My lord, on behalf of Mr. Devashish Tripathi, my lord, recusant already filed, my lord, in this case, my lord.
It's all right. What's the matter about? What is the matter about, sir?
Only instruction from by phone, my lord, finally.
Dangerous to appear in this court on all these instructions without brief. You have the brief or you don't have? No.
No, on behalf of Mr. Devashish Tripathi, my lord.
Doesn't work here, sir.
Next
What's the matter about?
Kindly give.
No.
No.
Quash. 1cc.
Recusant already filed.
420, 423, 468, 471. Permitting the petitioner to raise all please the appropriate stage. Just put down his name. Petition is disposed of. All right.
Item 41.
None appears dismissed.
Item 42.
42, no instruction. Because
no instructions dismissed. All right.
Item 43.
None appears dismissed.
Item number 44.
None appears dismissed.
Item number 45.
None appears dismissed.
Item 46.
None appears.
Item number 47.
None appears dismissed.
48.
Same order.
49.
Your lordship, the matter has become infractious.
All right. Dismissed as infractious.
Item 50.
None appears dismissed.
51.
In this case, the petitioner has come up for passing of the proceeding against him because none of the witnesses, neither in the affair nor in the witness statement, has stated about the overact committed by the present petitioner. And till now, so far as my information goes, out of 20 witnesses, 9 witnesses has already been examined, none has spoken a single word against.
302, sir. 302. You'll have to prove your case. All right. Permitting the petitioner to raise all pleas at the appropriate stage. Petition is dismissed.
Item 52.
None appears dismissed.
Item 53.
Your Lordship, behalf of DG Sahu praying for 1 week time, my lord, to remove the defects.
No, what's the matter about? This is a matter of 2020, filed in 2020.
Yes, my lord.
Charge sheet has already been filed, madam.
Yes, Your Lordship.
Permitting the petitioner to raise all pleas at the appropriate stage, petition is dismissed. All right.
Obliged, Your Lordship.
54 already voted. Item 55.
None appears.
Same, Your Lordship.
Same. All
Yes,
right.
Your Lordship.
55, same. All right.
Obliged, Your
Item
Lordship.
56.
None appears dismissed.
Item 57.
None appears dismissed.
58.
Same order.
Item 59.
Same order.
Item number 60.
Also prayer for crossing the proceeding under section 420, 294 and 34 IPC. The present petitions are the elder brother and sister-in-law of the informant. And the present case is arising out of a civil dispute under Annexure 2, which is pending in the Civil Judge Senior Division, Jaspur Lordship.
One day you'll have to settle, only then it will happen. Otherwise, it won't happen. You're there? No. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. All right.
Item number 61.
May I please, Your Lordship? Your Lordship, the present petitioner challenging the cognizance order passing by in 1CC case number 102 of 2019, my lord. Here in this case, the bank persons will misappropriate the documents placed by the petitioner that the loan amount is not sanctioned. But after that, they sanction the loan and misappropriate the money. And after that, they are filing 138 case against me. And the part when come to notice of the present petitioner, he filing an FIR and the bank manager and the employee dragged to court and filing for the bail application. So, my lord, I am not involved in the 138 NIA case. No, I am not granted the loan. That is misappropriated by the bank employee. I am availing for a tractor loan, but the tractor loan is not available.
All right. Raise all the pleas. You say permitting the petitioner to raise all pleas at the appropriate stage.
Obliged.
The petition is disposed. All right.
Item 62.
Passing of cognizance matter 498 case and 323,506 matter. Notice was issued.
Nobody's appeared, sir. Permitting the petitioner to raise all pleas at the appropriate stage. All right.
Item number 63.
Addressee left.
The matrimonial dispute has been resolved. Decree of divorce on mutual consent has
Nobody's appearing on the other side, sir.
My lord, they have the victim, my wife has appeared and he has also filed affidavit.
Okay, who's there? Who's the other side?
Mr. A. Sahu along with another has appeared and he has also filed affidavit serving a copy on me.
Where is that affidavit?
And the order of the honorable
There's an affidavit filed by opposite party number 2. Wife stating that the marriage between her and the petitioner already stands dissolved by the decree of divorce under section 13 capital B of the Imbue Marriage Act 1955 by the Family Court Bhadrak in CP number 250 of 2019. A copy of the said decree has also been enclosed. She has further stated that all disputes have been settled and she does not wish to pursue the criminal case against the petitioner. Can take from the prayer clause and all proceedings consequent thereto hereby cautioned.
Item number 64.
My lord, on behalf of Mr. Mr. My lord, appearing for the petitioner is advocate of this honorable court. There is a matrimonial dispute between the petitioner husband and the wife. My lord, there is a chance of settlement. Notice is not sufficient. Kindly order.
Permitting the petitioner to raise all pleas in the appropriate stage. The petitioner. Right.
65.
65, my lord, may please, Lord. My lord, here allegations are all civil in nature. They have initiated a criminal proceeding for which I have come to cause that criminal proceeding.
So, Lordship, permitting the petitioner to raise all pleas at the appropriate stage. Petition is dismissed. All right.
Item 66.
None appears dismissed.
67.
None appears dismissed.
68.
Same order.
Item number 69.
Same order.
Item 70.
May I please, your lordship?
Yes.
Item 70,
Yes.
may your lordship, the petitioner seeks to challenge the FIR laws special case 75/18, Annex 2, your lordship.
Yes.
Fact is that the petitioner number one is a doctor and two is her father. He is also a doctor. And the fact is that she is working as a medical officer, Moirubhanj, while returning from hospital from discharging her duties at about 12:30 on 6th November 2018, was stopped by police, her vehicle checking. On demand, the petitioner produced
Madam,
all
you can't attack a policewoman and expect to get away. How can you go into the police station and attack the policewoman?
Kindly, your lordship, see paragraph 6, your lordship.
Yes.
He has demanded illegal bribe. I am
All this
objecting
will have to
that,
be, let me examine with the trial court. All right. Permitting the petitioners to raise all pleas at the appropriate stage. The petition is disposed of. Yes.
Item 71.
None appears dismissed.
72.
Same order.
But 72 we are there, my lords. Mr. Pandey is online.
Ha.
My lords, here actually there is an memorandum of understanding.
72?
Yes, my lords.
Because your name doesn't appear in the list.
Lords, on behalf of Mr. Mahanti, Mr. Pandey is engaged.
No, I'm sorry, that is 75.
75.
I'm
sorry,
sorry.
72. Your name doesn't appear, I was wondering.
None.
None appears dismissed.
Item 73.
May it be pleased, your lordship. Offense under section 302, 201, 34 of IPC, your lordship. My lord, the total of this is the second journey of the application of the petitioner number 3 and 4. My lord, a total of 8 witnesses has been examined and all the 8 witnesses has been turned hostile. And my lord, one Sodisuko has been released on bail by Honorable Justice Sangam Sahu in BLAPL number 1521 of 2022.
All right. You say list before the. It is stated that in the instance of one of the co-accused,
yes, sir.
A bail order has been passed by Justice Sangam Sahu in BLAPL number
1521 of 2022.
1521 of 2022 on
16/1/2023.
16/1/2023. List before the same bench.
Okay, sir.
1st May.
Item 74.
May I please, your lordship. Here, my lord, the petitioner is a retired police officer, my lord. While working as the assistant sub-inspector of police in Fulbani headquarters, my lord, the complainant had filed a case, my lord, against the petitioner. And on instruction of the higher-ups, my lord, he conducted the raid and the vehicle, which was alleged to be the stolen property, that was seized by the police officers. And the vehicle was kept in the police premises. Thereafter, my lord, a final form was filed saying that this is a mistake of fact. The complainant filed the case. Then the protest petition was filed by the complainant, my lord, against the petitioner along with other police officers. Then, my lord, this honorable court has been pleased to stay that order of taking cognizance, my lord. And now, my lord, the person is 64 years old, my lord.
It's all right. So you can, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. The interim order is vacated. Right.
Only I pray, my lord, let it be protected, my lord.
No. That you know, sir. It doesn't know. Yes.
75.
In 75, my lord,
yes,
a partnership firm has been named as an accused in a complaint.
Oh.
Lordship knows that partnership firms are not juristic persons. They cannot be pleaded as accused persons, and it is the partners themselves who can only be the accused. And cognizance has been taken against the partnership firm, which I have.
But why not? I think in NI Act, just show the NI Act. I'm not sure. You're right. Why can't a firm be impleaded?
My lords, only a company is a juristic person.
No. Why even a partnership firm is a juristic person?
My respective submission is that the law is well settled even in Black's dictionary. My lords, a partnership firm cannot be a juristic person.
No, sir.
Lords, how can a firm cheat? It is the partners who can cheat, my lords.
No.
Firm cannot cheat. And the firm cannot misappropriate. It is the partners who will misappropriate.
I think there are cases against firms which have been registered.
In any event, my lords, the parties have settled the matter between themselves now.
Have they?
Yes, my lord. They got the information in the morning, my lord. That matter has already been settled. Moreover, they have already paid the amount, my lord.
So you are appearing for the informant.
No. I am the opposite party. I have lost the complaint.
That's
case,
right.
Much obliged. Then thereafter, they have paid some of the amount.
Some of the amount.
Much. Near about.
No, the only short question Mr. Panda wants to know is, are you agreeing to his prayer or not?
So for that amount, they have already paid, my lord. Matter is settled, my lord.
No, he wants to know, will you agree to the prayer made, quashing the proceeding?
No, my lord. When the matter has already been settled, my lord.
So why should the criminal case continue?
That's why if they are agreed and matter is settled, so automatically they are paying the amount. So matter has to be dropped.
So you are agreeing?
Yes, ma'am. If they are paying that is settlement. So question of proceeding with it.
All right, counsel appearing for the opposite party agrees that the entire amount has been received from
the entire amount, near about 50%, my lord. Amount is already
Settlement.
They are go on paying, my lord.
They're going on paying.
Yes, my lord, as per settlement.
All right. So you are not opposing to the prayer for quashing.
So for that, that is
difficult. Are you clear or you want to take time to get instructions?
I'll take the instruction to what amount they have paid, my lord, to that extent, my lord.
Counsel
15 lakhs millers has been paid in the meanwhile.
All right. Mr. Panda, learned counsel appearing for the petitioner states that the opposite party has already been paid rupees 15 lakhs.
They have already paid 40 lakhs millers.
40 out of 0 lakhs out of
80 lakhs.
80 lakhs.
All right. Counsel for the opposite party, while not denying the above submission, states that he wants to seek instructions on whether the opposite party will agree to the prayer made in the present petition. List before the roster bench on 12th July. There's an interim order.
There's no interim
order. No interim
order. All right. Interim order to continue.
Item number 76.
Item 76 may be listened. The matter has been amicably settled between the two parties. The present person has already married the daughter of the informant. The victim has also stated that she is major one and now she is living and married to the.
All right. An affidavit has been filed by the opposite party number. Daughter of opposite party.
Daughter of the opposite party number.
Yeah, opposite party number 2. Stating that she has married the petitioner and is living happily. Just look at annexure 2. It's in Odia, that's why I don't know. Is that what she's saying? Shraddhanjali Das, that's her name.
Shraddhanjali Das Milsi. The affidavit has not filed Milsi. The only matter has
annexure 2.
Yes, madam.
The matter has been amicably settled, my lord. They are living happily, my lord.
All right. In that view of the matter takes from the prayer clause and all proceedings consequent that way hereby quashed.
Item 77.
Hello, item 77 appearing for the opposite party number 2 on behalf of Mr.
petitioner. Dismissal number. All right.
78.
May I please, your lordship? My lord, all the points arise before the trial court.
All right. Permitting the petitioner to raise all, please.
Item number 79.
All right.
May I please, Your Lordship? The present petitioner, in the instant case, my lord, the decree of divorce and permanent alimony has been awarded in the year 2017. In 2019, the opposite party come forward and claiming maintenance, which has been deprecated by the Honorable Apex Court, my lord. I have cited in many cases before, Your Lordship. Once permanent decree of divorce is there and permanent alimony has been awarded.
No, but what has happened in that case? The stay granted to this court.
My lord, in permanent
have you served the other side or not?
My lord.
Let's see if anyone is appearing for the opposite party.
And to that extent, my lord, 2011 volume 12.
1 minute. Dear Sundar Rai,
Sundar Rai, my lord, I have got instruction that his father has died.
Oh.
He has attending the Oscar ceremony.
All right, all right. Counsel appearing for the
After that, yes, sir.
opposite party is stated to be in some personal difficulty. List before the roster bench on 6th July. Interim order to continue.
Problem. Item number 80.
May please your lordship, my lord. The matter is amicable settled between the parties, my lord. My learned brother is appearing on behalf of the informant, my lord. He is appearing in the VC due to some personal difficulties, my lord. Mr. MDG Madani, my lord.
My lord, I am appearing.
All right. Mr. Madani, learned counsel appearing for opposite party number 2 confirms that the parties have settled the disputes and therefore does not oppose the prayer made in the present petition. Consequently, take from the prayer clause and all proceedings consequent thereto hereby quashed. All right.
81.
None appears.
For the opposite party, number 2.
None appears to the petitioner. He is for the opposite party number 2.
Item number 82.
The petitioners, in this case, is the unit head, was the unit head of whether the Lanjewad unit, my lord. And what happened, my lord, there is a tussle between the security forces and the villagers. Security forces deployed by the company, the Orissa Industrial Security Force, that is the government of Orissa owned controlled security force, my lord. And that is then in the couple, the one security staff died and another person died in the pond in the drowning stage and also with the liquor, liquor.
302, sir. Permitting the petitioner to raise all pleas. Petitioners to raise all pleas at the appropriate stage.
My appearance may be noted, my lords, for the opposite.
All right. All right. All right. All right. All right.
Item 83.
May I please your lordship? My lord, the petitioner is the accused. Opposite party is the complainant. Kindly have a glance to complaint petition running page 9, my lord. Paragraph C. That the complainant presented the said check on 28/2.
1 minute. Where is Mr. Mahapatra? B. N. Mahapatra. All right, Mr. B. N. Mahapatra was appearing for the opposite party is not present today. The registry will inform him telephonically to remain present by the next date. This is for the roster bench on 19 July. Interim order to continue.
84.
May I please, your lordship? There is no instruction, my lord. I pray for withdrawn.
All right. All right. Dismiss is withdrawn. No instructions. All right.
Item 85.
May I please, your lordship? The petitioner here is a government servant. The FIR is of 2010 regarding section 468 and 471, my lord. My lord, kindly. 2010 FIR. My CRLMC, because of delay in their investigation for 10 years, I have filed in 2020. In 2020, I filed the CRLMC. I did not get any stay that time. And 2022, after getting the notice of the CRLMC, they are filing the charge sheet on 9/1/2022 after 12 years, my lord.
Now it's all right.
My lord, it is a settled position. I have got 3 research judgments of Honorable Apex Court regarding the same, where they have delayed for 6 years of filing charge sheet.
Charge sheet has been filed, sir.
Sir, after 12 years.
That will be ground for you to seek discharge. It appears that now charge sheet has been filed.
Kindly, my decisions may be taken into record.
No. It will be open to the petitioner to urge all the pleas raised in the present petition, including the case laws to be cited regarding delay in filing charge sheet
for 12 years.
Trial court at the appropriate stage. Right. The petition is disposed of. Interim order is vacated. Right.
Obligation.
86.
Please, your lordship. Lordship, can I glance to page 19, order of cognizance by the Law and Trial Court. The case record is put up today for order of the point of cognizance, peruse the complaint petition along with the initial statement and the complaint and the statement witnesses exam 202. On perusal of the appears a prima facie case made out under section 294/5034 IPC against the accused persons, namely Vijay Kunuba and Purnachandra Sahu. I am for the Purnachandra Sahu here. Hence, cognizance of the offence 294/5034 is taken against the accused persons. Issue notice. Then your lordship may kindly have glance to page 16, the initial statement. Not a single word has been whispered by the complainant herself against the present petitioner. So cognizance has been taken mechanically without application of mind. Page 16 may kindly have glance. Deposition of witness, so page 15, annexure 2. I am the complainant of this case. I have filed this case against the Vijay Kona Purnachandra Sahu. The occurrence took place to 27/2015 at our house, Sankarisai, such and such. The para 2 is relevant. My husband silently watching him. He is innocent man. The Vijay Bhuya, another accused, went to the house and brought a kotari and showing the kotari, he threatened threatened us to slaughter by means of the Qatari. Out of fear, I shouted. Hearing the shout, the villagers came to the spot and they said, Vijay Bhuya, fled away from the spot. Then we reported the matter to the PS police. PS police called us to PS several times, and at last they told us that we have a civil dispute and told us file complaint case against the Nayab. Not a single word has been whispered against the present petitioner in the initial statement. Even to the extent the complaint petition will have a glance, then there is no whisper about anything, any scolding or any threatening or anything else.
So the 294, I don't know how it's attracted.
Yes, that's
Yes, sir. What do you say?
Instruction of suffer at the last date.
No, you say a perusal of the statement of the complainant reveals that there is absolutely no allegation whatsoever against the present petitioner, either for the offense under section 294 IPC or section 506 IPC, both of in respect of both of which cognizance has been taken against the present petitioner.
I may be pardon, my lord. One thing, my lord. In the complaint petition, my lord, it has been stated that accused persons, my lord. And the accused has been added.
The statement is recorded with the name, sir.
Yes, my lord.
That's why 200 is insisting on that.
There is no material.
This being a complaint case, it was essential for the complainant to have named specifically the petitioner and mentioned the overt act which attracts the offense. Paragraph. Clearly, therefore, the impugned order dated 18 June 2019 passed by the learned SDJM Jagat Singhpur in 1cc number 434 of 2018, qua the present petitioner, has been passed without any application of mind. The said order is accordingly hereby quashed vis-a-vis the present petitioner alone. The petition is allowed to develop.
18/6/19, the order impugned.
That's what I've said.
All. Obliging. Hello.
Item number 87.
None appears.
88.
My lord, in this case, the notice has been issued to the opposite partner to, and the noting is the AD received for the from opposite partner to after valid service. My lord. My lord, this is a case under section 138 of the NI Act. My lord, petitioner has filed a petition. Petitioner is the accused person. Filed a petition for examination of the material witness, who is the son-in-law of the complainant, my lord, opposite partner, and the business partner, through which the petitioners of the check, my lord. My lord, the petitioner filed the petition before the court below for examination of the material witness, who is the business partner, from which the check has been collected, my lord.
Yes.
Pursuant to notice, my lord, the OP number 2 is the complainant has to be appeared, my lord. Notice has already been issued, my lord.
No. The present petition is directed against the orders dated 29 January 2019 passed by the JMFC Bhubaneswar in 1cc number 2923 of 2015, rejecting the petition of the present petitioner bracket accused for recall of the son-in-law of the complainant for being examined, for being cross-examined, and the subsequent order dated 27th August 2019 passed by the Sessions Judge Khurda, dismissing the petitioner's criminal revision number 37 of 2019, affirming the above order. Paragraph. The JMFC has observed that the complaint itself was of the year 2015, and 3 years after the complainant had been examined, the above petition was filed. Full stop. The complainant mentioned about knowing the accused through her son-in-law but otherwise did not state that any of the transactions appeared in the presence of the son-in-law. Full stop. At the stage of defense evidence, the above application was filed, which obviously would result in delaying the proceedings. Paragraph. The court does not find any merit in the contention of the petitioner that the son-in-law was necessary to be recalled for a cross-examination. Consequently, the the court is unable to find any error having been committed either by the JMC or the learned additional sessions judge. Sorry, or by the sessions judge Khurda in passing the respective impugned orders. The petition is accordingly dismissed. The interim order is vacated. Copy of the order be sent forthwith to the JMFC, Bhubaneswar, before whom 1CC case number 2923 of 2015 is pending. Right.
Item number 89.
The opposite party.
All right. None appears to the petitioner. Put down his name. Dismiss or non-dismiss.
My presence may require.
Item number 90.
None appears dismissed.
Petitioner Lordship is inside custody since 29/3/2012, Your Lordship. More than 10 years inside custody, Your Lordship. And he was in convicted under section 302/34. Other petitioners was granted bail in criminal appeal number 533 of 2015. As a present petitioner is concerned, his bail application was not raised in 2015, Your Lordship. Allegation is that there was long.
So this is 872 of 2019.
My lord.
All right.
Yes.
Yes. What do you say?
No, it's 10 years in custody.
All right. So 10 years has crossed. All right.
It's more than 11 years.
Correct. 872 of 2019. The applicant has been in custody for more than 11 years now. All the accused appellants in the connected criminal appeal 533 on 2015 have already been enlarged on bail. it is not likely that these criminal appeals in the usual course will be heard in the immediate future. Full stop. Paper books are yet to be prepared in these appeals. Keeping in view the above circumstances and the judgment of the Supreme Court in Singada Singh, the court directs that during the pendency of the present appeal, the applicant be released on bail, subject to terms to be set by the trial court.
This is criminal appeal
Subject to the terms set by and to the satisfaction of the trial court.
This is criminal appeal 534 of 2015, Your Lordship.
Yeah, this is 534. Correct. Correct. All right.
Item number 2.
Okay. None appears dismissed for non-prosecution.
Item number 3.
In item number 1, there is stay realization of fine amount. Item number 1, Your Lordship.
Yeah, that will continue, sir. You have not prayed for it earlier.
No, it was not.
Okay. Further, there will be a stay of the fine amount. All right.
Obliged.
Item 3.
May the CMAPL for restoration of the previous CMAPL, which were dismissed on 17th March 2023. On that date, my lord, I have enclosed the cause list. My name was not reflecting in the cause list, though I filed my power on 22nd February.
What does that mean, matter about?
Well, that is against the judgment passed by the learned judge family court.
That was also dismissed for default.
Default.
Yes,
Right.
that was also dismissed for default. I filed fresh power on 22nd February, but in the cause list, my name was not appearing.
All right. You say, for the reason stated therein, this application is allowed.
Nine.
The earlier order dismissing CMAPL 110 of 2015 is recalled. That CMAPL is restored to file. In that, you say, for the reason stated, that application is allowed. And Mata 53 of 2009 is restored to file. And in Mata 53 of 2009, you say today the present appeal has been restored by virtue of the order passed in CMAPL 110 of 2015. List before the roster bench on 17 July.
Obliged.
17 July.
Obliged.
Right. Thank you.
That's it. I've wrongly left item number 2.
Bench is over, sir. We'll have to file now. Now it's this.
For orders, item number 1.
Let's it is. I am filing since last 10 years in the judicial fight.
See that bench is over, sir. This is a different bench. Right.
In this case, I have filed an application for recall of the order dated 15/5/2017.
Right.
Wherein the repetition has been dismissed as withdrawn and no instruction. When the petitioner counsel has no instruction, the repetition should not have been withdrawn.
You're not impressed with this kind of submissions.
Mr. Satpathy, what kind of submission is this?
Yes.
The liberty granted to the petitioner.
You are not the counsel. Somebody else was the counsel.
Exactly.
So it's very convenient. No, this is a standard practice.
Since this has been dismissed in 2017.
No. Sorry, please.
Sorry.
No grounds made out for recall of the order. The IA is dismissed. Right.
Item number 2.
May I please, Your Lordship? My lord, there is 14 number of appellants before Your Lordship. I am only praying for appellant number 14, Your Lordship. That is Robbie Sundar Rai. Others was granted bail, Your Lordship. His bail application was rejected in 27/9/2016, and he is inside custody since 2014, Your Lordship.
But there is direct allegation against you.
Yes, that is because of that allegation.
Hastily killing. There is direct eyewitnesses are there. The direct allegations are there.
My lord, he is inside custody near about 9 years, Your Lordship.
9 years.
2014, Your Lordship.
How many killings? One person died. How many accused?
There
14.
are 14 accused, Your Lordship.
By scaling over the wall of the house, you drag the deceased and
This
killed him.
petitioner is concerned, he attacked on the legs, your lordship. This number of eyewitness.
Repeated attack on by Kati.
On the legs, your lordship. On the legs is concerned, your lordship. There's such.
9 years, sir.
Oh, yes. Lots of.
All the others have been enlarged on bail.
Most of them are enlarged.
No, what is the most?
Not all, your lordship.
Not all.
Okay.
Most of them was granted bail.
Most meaning how many?
Exactly, my lord, they are different. 8 was granted bail, 9 was granted bail, 10 was granted bail, 11 was granted bail.
Except after numbers 5, 6, 7, 13 and 14. Rest are
all right. There are 14 accused in all, of which except 5 of them, including the present appellant, applicant, that is accused number 14. What is his name, please?
Rabi Sundar Rai.
The other co-accused have all been enlarged in bail. Paragraph. The present appellant has been in custody for over 9 years now. Stop. The paper books in the criminal appeal are yet to be prepared, and therefore it's unlikely that the present appeal will be listed in the usual course in the immediate future. Stop. Keeping in view the above circumstances and in view of the judgment of the Supreme Court in Singara Singh, the court directs that during the pendency of the present appeal, the present applicant Rabi Sundar Rai, bracket accused number 14, bracket, will be enlarged on bail during the pendency of the appeal, subject to the satisfaction of the trial court.
Highly obliged.
In the main criminal appeal, you say paper books be prepared and be supplied to the parties within 8 weeks, thereafter to be immediately included in the list of final hearing appeals.
Obliged. I must stand corrected, is except appellant number 6, 7 and 14.
6, 7, 3 alone. Okay.
Yes.
6, 7 and 14. Yes, yes, Mr. Kati.
3 including the president. All right.
Great.
Item number 3. Well, conviction is under section 304B by 34 of the Indian Penal Code, related to section 4 of the DP Act, and sentence is life. And my lord, I am in custody since around 10 months, 9 years, 8 months.
9 years, 8 months. All right.
All other accused have already been released.
Okay. You say this IA number 378 of 2022. The appellant has been in custody for over 9 years and 8 months, and the other co-accused have already been enlarged on bail. Paper books are yet to be prepared in the criminal appeal, and it is unlikely in its usual course to be listed for hearing in the immediate future, keeping in view the above circumstances and the judgment of the Supreme Court in Singara Singh. The present applicant, Litu alias Lalita Kumar Ghana, is directed to be enlarged on bail during the pendency of the appeal, subject to the satisfactory reply. The main appeal is say paper books be prepared and supplied to the parties within 8 weeks. Thereafter, the criminal appeal be included in the list of final hearing matters.
Item number 4.
May I please? My lord, this review application is in file against the order passed by this honorable court.
What's the delay, sir?
Delay, sorry, my lord. Delay, there has been delay. Since I pray, my lord, since a question of law is involved, if the lordship can kindly condone that delay and hear me.
What is the delay, sir?
There, 116 days.
Huh?
116 days.
No, 1 minute.
No.
Delay is
123 days.
Yes.
All right. Tell us on merits.
Yes.
What is it?
Yes. And I oblige, my lord. Your lordship may kindly come to page 82, where from the order starts, passed by this honorable court. Page 82. none appears for the parties. A memo has been filed by learned counsel for the petitioner stating therein that the above writ petitions are squarely covered by the judgments rendered by this court in Krishna Chandra Naik versus Railway Board and others dated so and so, which has been upheld by the Honorable Apex Court in SLP number so and so, copies of which have been annexed to the said memo, perused the said memo and taken on record. Your Lordship may kindly come to page 86. Page 86, my lord.
Yeah.
Para 6. On rival contentions of the parties, the following questions arise for consideration by this court. Whether the notification dated 16/7/2010 issued by the Railway Board is applicable to the case of the present petitioner, whether the petitioner is entitled to get the benefit flowing from the said notification dated 16/7/2010, and third is tribunal's order. 16/7/2010. Your Lordship may, since in the order 16/7/2010 has been taken note of, but in its entirety is not there. That is why I'm giving to your Lordship, that is 16/7/2010, RBE 99 of 2010. Clause 8 has been taken note of by this Honorable Court while dealing with the matter. Clause 8, your Lordship will find, it says whether it is retrospective or prospective. Clause 8 says these instructions normally will not be applicable in those cases where land acquisition process has been concluded by possession of land by railway. Your Lordship held that it is retrospective, which has been upheld by the Honorable Supreme Court. That is Krishna Chandra Naik's case. This Honorable Court decided the matter relying on the judgment rendered by Krishna Chandra Naik's case, which has been upheld by the Honorable Supreme Court. Dispute is not there, madam. Thereafter, after the Krishna Chandra Naik's case, your Lordship may kindly see Annexure 3, another judgment came. That matter relates to Odisha, which has been allowed by this Honorable Court. SLP was filed. It is available at page 92. There, the Honorable Supreme Court has said, first time, page 92, my lord, the issue in the present appeals pertain to the rehabilitation of land houses whose lands were acquired between 84-85, 92-93 for the Sambalpur Talchel rail link project. Your Lordship may kindly come to page 94 thereafter. No, but here clause 5 has been dealt with.
No, it was on the same day as this court passed the order. Just see, the Supreme Court judgment is 14th March.
Yes.
2019. And what is the date of this court's order?
Possibly I couldn't express myself properly.
No.
No.
19 September 2019.
Yes, there is no dispute over there.
No. So you did not place this judgment of 14th March before us. When the matter was argued in this court.
It was not, it couldn't be placed. That is why a review application was filed.
No, why couldn't it be placed? It was available to you.
That time it was not available.
No, you didn't appear at all. The whole problem is you never appeared.
Yes, your Lordship is correct. On the basis on a memo filed by the petitioner that it is covered by the case Krishna Chandra Naik, your Lordship passed on.
But has the subsequent judgment overruled Krishna Chandra Naik?
No. That is why I said I couldn't express properly. The document I gave to your Lordship, Krishna Chandra Naik matter deals with clause 8, retrospective or prospective. This other judgment relates to clause 5. Clause 5 of that document reads, the applicant should normally fulfill the eligibility and other conditions prescribed for the post against direct recruitment quota from open market. In special cases, general manager of the railway can relax these conditions. And in respect of the educational qualification, the applicant with read and write only capability shall also be considered. We are doing what we are doing. We are not flouting the order passed by this Honorable Court or the Honorable Supreme Court. We are willing to give that appointment. Only we want them to pass this test. That they are not willing to.
How do you know they are not willing to?
Exactly.
See, there has been no stay. What have you done in the meanwhile?
In the meanwhile, to be truthful, it has not been implemented. They have not been given appointment. But they have been asked to sit a 30% mark only.
No. Where have you written to them saying, please sit in a test? Where is that?
Yes.
Where is that?
What is that?
Sorry, man.
Where is that document you've sent them saying, now come and write a test?
And
where is that?
That document is not available in the review petition.
And where is the refusal to take the test? Where is that?
that possibly my land friend may not dispute that.
They have already given an appointment recently, my lords. One of the review applications.
What is this?
Hey,
You are already
Mr.
implementing,
Das.
then this is too much.
That is in a contempt petition. That is in a
Maybe.
No, sir, you implement.
Maybe.
That's the end of it.
We are not.
These cases, contempt applications have been written.
Oh,
Yes, it also have come also today.
oh, I see.
All the
It has
cases
been brought to the notice of this court by counsel appearing for the opposite parties that during the pendency of these review petitions, contempt petitions were filed in the connected writ petitions, and in one of them, an order has been issued by the railways implementing the order of which review has been sought. Paragraph. In view of the above development, the court is not inclined to entertain the present review petition, while clarifying that the order under review will be confined to the facts of the cases and will not constitute a precedent for other cases.
only I pray, my lord. You will also grant me some time so that the order can be implemented.
In the contempt petition, you say list before the roster bench.
It has come today, my lord.
That's right. It will come before the roster bench now.
Roster bench.
Roster bench on 17th July. The contempt petition will come with the roster bench. Review petition delays condoned, dismissed on merits.
4, 5, and 6, my lord.
Right. 4, 5, and 6. Right.
4, 5, and 6.
All right.
Item number 7.
7 well, Mr. Acharya, senior counsel is on BC. There may be some technical problem. Ye connected, madam. Ye connected, madam.
Item number 7.
Yes, my lord.
Several defects are there. Some technical problem, I think. He is on BC. Yes.
All right. You say for the reasons stated therein, the CM appeal is allowed and review petition so and so the rest of the. Now, yes, argue the review petition, sir.
Argue the review petition.
CM appeal has been allowed. Please argue the review petition now.
Yes, my lord. Now, your lordship may kindly come to page 13 of the review petition, my lord. That is the impugned order. Here, what has happened, before I go to that impugned order, let me just put a small facts of the case, my lord. In 1974, one landless person was granted a lease, my lord, of 1 acre, and he was given the possession. Thereafter, in 1985, he sold this particular patch of land to me and another 3 other persons, my lord. And we got the possession and the sale deed was executed. Now, in 87, the lease was cancelled so moto without making us a party. We filed a writ application before this honorable court and the order of the ADA was quashed and I was allowed to participate in that revision case, my lord. And that revision case was dismissed. Thereafter, I filed a second writ petition in 2014 and the impugned order is at page 13, my lord. The lord may kindly come to page 13 for a moment.
Yes.
I'll just read the last paragraph, paragraph number 6. Due to non-production of any materials whatsoever by the petitioner before the revisional authority and on inquiry as the said authority has found that the lessee is not, it does not belong to the local area, it was held that the lease has been granted by suppressing material facts. The petitioner being a defaulter in producing materials whatsoever, he cannot claim the advantage of his laches and abuse the process of court repeatedly. Therefore, the revisional authority by the impugned order rightly cancelled the lease granted in favor of Kasim Behr in WL case number so and so, as the same was illegal and invalid. Now, what has happened after passing of this impugned order, we try to verify actually whether this person belonged to that particular area or not, and we could ascertain that he was a native of that same village. And at page number 31, 32, and 34, my lord, 36, 33, let me kindly come to page 31 for a moment. So this is the ration card issued in favor of the original lessee, that is Kasinath Behra, my lords. And if your lords will come to the next page, back side, it says the same village in which the lease has been granted and where this person has been residing, my lord. That is Pathargadia in Chandaka block, my lord. And thereafter, page 32 is the voter ID card of the son of the original lessee, my lord. Then page 33 is the ration card, which also shows that he belongs to the same village, my lord. So these documents, we could not produce it at the time of hearing of the writ application and we have subsequently managed to get it, my lord. These are my sole grounds, my lord.
Who's for the opposite party? Who's for the opposite party?
No, notice has not been issued, my lord. Here only state is the opposite party.
State is the opposite party.
Yes, yes, my lord.
No, there is also one Kashi Behra, opposite
He
party.
is the original lessee, but he has, in the meantime, he has died, my lord.
Then he has to be substituted.
Has he been substituted?
He has to be substituted by his
So you'll have to file an application. You say in the review petition, you say, Mr. Acharya and its senior counsel for the petitioners states that opposite party before Kashi Behra has expired. During the pendency of the present petition, he states steps will be taken to have his legal representatives brought on record. List on, we'll have it after the opening. List on 7 July.
Grateful, man.
May I request my learned senior to serve a copy of the review?
Yeah, copy of the review petition be served and counsel with the state forthwith.
I'll do that, man. I'll do that.
All right.
Item number 8.
Well, I'm submitting my appearance today for opposite party. Next sitting in the summons, I will submit my further case.
Lordship has issued notice
Yes.
on 5/7/2022.
Yes.
And Anand Khan has appeared.
How is it the bench has changed?
Yes.
Review petition was before just Raman.
Yes. It is.
Subsequently, perhaps it has been pointed out, thereafter.
And then it came before Justice Sahu, MS Sahu.
my
Original order was passed by whom?
Justice Pandamal and Justice Mahapatra.
That may be the reason.
Lordship can find it from Annexure 1 of my review petition, page 20.
Okay.
Yes.
Yes. What's the my point now? Tell us.
Very short point, my lord. You also can find it from page 22, paragraph 3.
Yes.
That you'll also see that 11th line. Admittedly, the petitioner has already acquired BEd training qualifications since 28/3/1998. The entire dispute, my lord, he has not acquired the BEd qualification on 28/3/1998. I'll show my lords only a notification which is the cause of action before the tribunal. The lords may see annexure 4, page 39.
Yes.
What has happened in this case, my lord? Those untrained teachers are there in the school. We have given them a time limit to acquire their BEd qualification within a period of 2 years. You'll also say page 39. So he did not acquire that qualification. So he was terminated in 2001. He submitted it that he has acquired that training qualification with him. So on the basis of that, the order was passed and quashed that termination order. Subsequently, he filed a modification petition that not was omitted in that order, so not may be modified. The subsequent order to the first order. Again, he filed a modification that on 10/5/2018, you can find it from page 26 of my review application. There not was again added. So it changed the entire sequence of the order.
Yes, of course. Entire basis of this.
So,
Ingenious. Yes, sir. What do you say?
Yes, sir. Kindly give any other date. I will.
Why? There's no other date. Nothing. No question of other date.
So that,
when did he acquire the qualification, or he never acquired it? He never acquired it. Oh.
You never acquired that qualification.
Till 2000, he has not acquired. Till 2001, that you are terminated.
2001, he never acquired.
Yes, ma'am. That you can find it from my read petition, that is the impugn order.
Right. Because this is coming up after notice, sir. There have been several hearings here.
My lord, please give me one day at least.
No. We can't keep sitting every time, sir. We can't keep sitting. You say, in the order dated 9th March 2018, this court was dealing with the issue whether the termination of the writ petitioner's services by the order dated 9th March 2001 of the Inspector of Schools, Sambalpur Circle, Sambalpur, was justified. Full stop. That order came to be passed after noticing that the petitioner did not acquire the mandatory BEd training within 2 years of his order of approval of service dated 12th June 1998. Full stop. It was noted in the said order, open quotation, admittedly, the petitioner has already acquired B.Ed training / qualification since 28/3/98, unquote. Therefore, the order proceeded on that basis and set aside the termination order. Paragraph. Interestingly, within a few months, a miss case number 4504 of 2018 was filed to correct the above sentence in the order dated 9th March 2018. Full stop. This application was allowed by this court on 10th May 2018, whereby the word single quotes already was substituted in the above sentence was substituted by the word single quotes not. Full stop. Paragraph. Having allowed the above substitution, it is obvious that the writ petition could not have been allowed and the direction issued therein could not have been passed, as it changed the entire complexion of the case. Paragraph. For the aforementioned reasons, the court finds that the order dated 9th March 2018 is itself unsustainable in law and is hereby set aside. Is hereby reviewed and recalled. Writ petition civil 12350 of 2014 is restored to file. Then in 12350 of 2014, you want to argue this on some other day.
Yes, my lord.
Counsel for the petitioner prays for an adjournment to argue this petition on some other day. List before the roster bench on 17 July. The contempt petition, you say this petition will stand closed by virtue of the order dated passed today in review petition 158 of 2020. Right.
Sir,
Pranam, sir. First one is only for return of annexures. So allowed the annexures be returned subject to substitution with
Item 1.
attested photocopies. All right. Item 2 now.
Item 2.
Extension of time.
That is in infractions. The IOS filed for expediting the hearing of the first appellate authority.
That's over now.
Over, second appeal over, and I've got the refund.
Oh, I see. No wonder you're smiling so much.
But I am smiling because of the break benches your lordship have listed. So many break benches. I think your lordship will miss their lunch.
So on account of subsequent developments, this application has become infructuous and is disposed of.
Obliged.
Right. Right. Oh, very late.
Namaste, my lord.
Namaste, namaste, namaste.
For orders item number 1.
Here you also dispose the writ petition giving liberty to file appeal. But by mistake, appellate authority should be the sub-collector OP number 2.
All right. For the reasons stated therein, the application is allowed. It is clarified. No, which order?
No,
3B.
Sorry. You're in the wrong matter, sir.
CMAPL 3-1.
This is for the registration of the.
I know. So for the reasons stated, the CMAPL is allowed. Order dated 21 June 2022 is recalled and the writ petition is restored to file. Come in the main writ petition, sir. What is it about?
Exactly.
Monumental Sukhupara Hill shall not be excluded from OMC's sites. All right. This annexure 8 is the representation.
Well, the representation to is the Director General of Archaeological Society.
Make a fresh representation, sir. Make it to the proper person. Not like this. Is permitting the petitioner to make a proper representation to the authorities. And after following a sub-representation, to seek appropriate remedies in accordance with law, the petition is dismissed. All right.
Item number 2.
We are for the 1 and 3, my. All right. Sir.
Item 2. CMAPL 562 of 2022.
Item 4,
Item 2.
No, we are in item 2, sir. Pramod Kumar Bihari. None appears dismissed. All right. Item 3.
Item number 3.
Arjuna Behera.
The order is at unnecessary one at page 18, my lord. For review of the order of the. Even the
Kalyan Mandap.
Yes, even though the Kalyan Mandap was constructed by the time the order was passed, surprise is the fact that Kalyan Mandap an order has been obtained by lord.
Who has made that statement?
Open or 8 and then they have filed the writ petition, my lord.
No, resolved. Not that it's been completed.
Your lordship, just
read that order. Read that order.
Yes, ma'am. Kalyanam, which is the original to be constructed at Gaudapatna and then at Gopalapur.
Read the 5th May 2022 order.
Yes, ma'am.
Para 1.
Para 1. Mr. S.K. Dali, London Council for appearing for the intervention IA number so and so states that the present Panchayat Committee has resolved to construct the Kalyanam.
To construct, resolved to construct. Nobody said it's already constructed.
No. By the time the order, this order was passed, the earlier body has passed the order, resolved, Kalyanam has been constructed, my lord. This is the next body. After the election, the next body has passed the resolution, my lord.
All right.
By the time the order was passed.
If your lordship sees page 10, ground number N, he was the erstwhile surpurge. During his time tenure, the construction was continuing. Lordship, they see ground number P. In the meanwhile, the election took place and new surpurge came in. New surpurge came in as an intervener. He made the submission. That is his case.
Anyone agreed with the fresh decision?
Yes.
Can seek appropriate remedies.
Yes, madam. Thereafter, I filed erroneously filed a writ petition. And the writ petition was withdrawn. The liberty to file a review petition, my lord. But as because I am the Sarpanch, at the relevant time, I had issued a work order unnecessary. Your lordship to work order issued at unnecessary 13 series, my lord. Thereafter, running bill has been also submitted by the junior engineer.
No, only says pursues remedy in accordance with law.
Yes, ma'am.
No, this is not a ground for review, sir.
Now the construction must have been completed also.
Yeah. No grounds made out for review. The review.
Your lordship, unnecessary 17, my lord.
Yes.
Unnecessary 18 on page 14. Already construction is there, my lord.
It's all right. All right.
Item number 4.
Item 4. Right. Sorry, sir.
Unless the order is reviewed, my lord, earlier construction has been concluded, not concluded. Already 50% has been concluded, my lord.
It's all right. We're not interfering. We're not recalling. Yes. Sorry, sir. Yes.
One body has already been resolved. The second body will resolve that another will be shifted, my lord.
It's all right. It's all right. Yes.
Item number 4.
Item 4, if your lordship looks at, it was dismissed for non-prosecution on 11/5/22, my lord. The initial order, page paragraph 5, I have mentioned, 24/12/2010, notice was issued and interim order was granted. Subsequently, after the death of the original applicant, the file was returned to the advocate and he also appeared. But on the date, his name didn't appear.
All right. So for the reason stated, the order is recalled. This writ petition is restored to file along with the interim order. But then in the writ petition, you say today it's been restored. You see, list before the roster bench on 24th July, interim order to continue. All right.
Item number 5.
Interesting name, Mr. Mishra. Your client has a very interesting name.
Einstein.
All right.
Both the sons, in fact.
I see.
The original applicant was subsequently started practice, in fact.
Oh,
he expanded.
I see. All right.
Item 5. May please. On 10/8/2022, the writ application has been dismissed for non-prosecution.
All right. You say for the reason stated, it's recalled. This writ petition is restored to file. And the main writ petition is listed before the roster bench on 1st August. All right. All right. Namaskar. Namaskar, sir.
For orders item number 1.
My lord, as per the direction of your lordship, since the appeal is pending before the Commission of Encounters Appeals, a direction may please be issued for early disposal of the matter because the bank attachment has not yet been lifted.
All right.
Respect to that. Only direction but from your lordship as early as possible.
All right. Counsel to the parties have been heard. It's directed that the Commissioner of Income Tax Appeals should dispose of the pending appeal.
Yes, sir.
Not later than 6 months from today. What is the appeal number reference? Something has to be there, sir.
Nothing has been communicated because of the faceless matter. They have not communicated. Only acknowledgement is there with us regarding the proof of filing of appeal. But as per your lordship direction, appeal was filed on 13/12/2021.
No, by that time it must have been communicated, my lord. There are several queries and requirements are there, my lord, in national process, faceless process. It must have been communicated.
No notice, no intimation, even not in online system also I'm daily checking.
No, what is the appeal number, sir? How will the person know what appeal he's supposed to dispose of?
Appeal number, we have given that acknowledgement only. That is a long number of files of acknowledgement they have issued me. This is the evidence I have kept as per Lord's direction. Okay. But matter is pending.
Appeal stated have been filed by the appellant on?
Appeal was filed on 13/12/2021, my lord.
13/12/2021 within a period of 6 months from a date of communication of this order. Then you say order be communicated to the Commissioner of Income Tax Appeal, Rourkela Circle.
No, that is faceless. I don't know the faceless matter.
All right.
Then direct to be communicated to the
National Faceless Assessment.
Sambalpur, Commissioner of Appeal Sambalpur, my lord, so that we can upload in the National Faceless.
All right. So, Commissioner of Income Tax Appeal, Sambalpur. For further onward transmission of this order.
Right.
All right. For compliance. The application is disposed of.
Item number 2.
Published.
My lord, in item number 2, I seek a modification of order dated 15/12/2021, my lord. In the first paragraph, your lordship had directed in 1st January 2022, appeal to be filed within January 2022. But in the last paragraph, your lordship intended to for 1st February 2022. But
when did you file it?
We have not filed it yet.
You should not have waited so long, sir. Even if you assume it was 1st February, you should have filed it by 1st February.
Lordship, we immediately filed this application for modification.
Please, which means you've got yourself some 1.5 years more.
Lordship,
this is quite ingenious.
No, I have not filed. I will consult my client whether we have filed it or not. But
no, he has not filed it.
No, I don't know actually.
Then you find out, sir. You find out.
I will find it. I'll find out.
At the request of counsel, the appellant, list on 23rd June.
Copy may be served upon us.
Lordship. I will.
All right.
Item number 3.
My lord, no instruction.
No instructions dismissed.
My lord, I have a query.
Item number 4.
None appeals dismissed.
Item 4. This is an application for restoration of the writ appeal. And
writ appeal or petition?
No, writ appeal. The writ appeal on 6/23/20.
Writ petition.
Writ petition or appeal, sir?
Appeal, my lord.
Writ petition.
You have stated WBC.
Is in another next post.
You're in the next matter, sir. That's why you're getting confused. Next bench. Okay, that's even worse. All right.
Item number 4.
None appeals dismissed.
Item number 5.
Lordship, item 5 and 6. Lordship, please to permit me to take Is it audible, Lordship?
Yes.
Lordship, item 5 and 6. Lordship, please to permit me not to press both the INs.
Kindly proceed, sir.
He's not pressing the I.
Not pressing, okay.
want to press the I.
Dismissed is not pressed. All right, 5 and 6 dismissed is not pressed. All right.
Item number 6 also. Item
Same, 5 and 6 both.
Item 7.
Item 7. My lord, 2 weeks time be allow me to recall to SR remove the SR manual.
This is a special bench, sir. What is the matter about?
Matter the OGC number 14,181 by 1997 was dismissed for default non-prosecution on 14 March 2020.
All right, for the reasons stated, the application is allowed. This OJC is restored to file. What is this OJC about? It's a 1997 matter.
Yes, my lord. Conducting counsel is died on pandemic, my lord. So they are the petitioners are rustic villagers. They could not know about.
What's the matter about, sir?
The matter.
Endowment.
Challenge. Endowment matter, ma'am.
In that case, just don't allow it. Just in the CMAPL, just say notice returnable. Because we don't even know how many parties are still around. No point in restoring one 1997 matter. There are defects, right?
Yes, sir.
All right. You say list on 11th August, defects be removed in the meanwhile. All right.
Public.
Right. Right, sir. Now, all right.
Another, my lord, same bench, my lord, another order, the same order, I number 2273 of 2023. I have given memo. In one case, two members are there, and that was not listed. I have given another memo also.
For what?
Same order is in place of Tahsildar, it would be
some other matter.
Another matter.
Which is that other matter?
That is.
All right, taken on board.
2146, same order.
2146, all right, same.
Same date and same.
Taken on board, all right.
Item number 2.
For restoration, paragraph 2, I have given a reason. I was hospitalized on that day. Undergone an operation.
All right, for the reason stated there in the orders recalled. And this is restored to file. The main matter you say is list before the roster bench on 24 July.
Item number 3.
Three same, my lord. One day.
Item number 4.
This is an application for restoration, my lord. Order to the root appeal was dismissed for default on 4/1/23, my lord.
All right, same order. List before the roster bench on 1st August.
Yes.
Item number 5.
Please, your lordship. By the CMAPL application, I'm challenging the order dated 13/2/2023 for restoration of which wherein the WPC number 13712 of 2014 was dismissed, your lordship, for non-prosecution.
All right, same order. The delay is condoned, recalled, receives the roster bench on 2nd August.
Much obliged.
Item number 6.
Please, your lordship. My lord, dismissed for non-prosecution by the order dated 22/2/43, my lord.
All right, for the reason stated, same thing. This was the roster bench on 3rd August.
Obliged. Item number 7. Please, my lords. My lords, this is a transferred application, transferred brief. Although I filed Vokalat now, my name didn't appear in the cause list. I have enclosed the cause list along with my same appeal petition.
All right. The review petition is restored to file. What is in the review?
If your lordship will be kind enough to grant me sometime that transferred application, I'll have to.
No. What's the review petition about?
Review actually, as a matter of fact, my lord, upgradation of post from junior librarian to assistant librarian. That was benefit was extended in few colleges, whereas the petitioner where he was continuing, it was not accepted. Your lordship, kindly see the order passed by this.
Yes.
Only thing, may I read that portion, my lord?
Yes.
That is available in the second page. Further, as rightly contended by Mr. Saul and an additional comment advocate, the order and annexed 4, upgrading the post of junior librarian to assistant librarian in the year 98 is confined to Ramadevi Women's College only. It has no general application. It is a circular issued by the state government.
It's all right. No grounds made out. Review petitions dismissed. All right.
Item number 8.
This may due to non-prosecution, my lords. I have given the grounds for paragraph number 4, my lords.
When was it dismissed, sir?
On 19/1/2023.
All right. For the reason stated, it's recalled. This is restored to file. List before the roster bench on 2nd August.
Similar matter has already passed the order of this honorable court, my lords.
Same bench.
Yes, same bench.
All right. Taken on board. What is the order? Just show me. Oh, Narottam Ratha.
Yes.
All right. In the main matter, you say this Narottam Ratha. Same matter. All right.
Item number 9.
On 9 and 10 and another matter which lordship's kind permission which has not come on board. 3 IAs have been filed. But here the grievance is very limited. But the petitioner filed a writ petition for praying for a direction that his reprehension should be considered for eviction of the encroachers from the government land. And your lordship has been pleased to direct that the collector is to consider. Now only your lordship may kindly see annexed 1 what the collector has done. The collector is issuing a notice for eviction without following the provisions of the OPL Act. My only grievance is he should provide us an opportunity. He has issued a general.
Oh, IAS separate.
Now, your lordship will kindly see what has happened.
You can't have IAS like this.
Item 10, your lordship may kindly see.
Yes.
A revision is pending.
Yes.
The collector has granted a stay.
It's all
Now, what he has done.
Not IAS, sir, not IAS. You say counsel the petitioner is permitted to withdraw the present applications to seek other appropriate remedies as available to the petitioners in accordance.
9 and 10.
Both
And IAS
same
number,
order.
my lord, 5870 may be taken on board also.
Taken on board in same order. All right.
Obliged.
All right.
Item 11. Item number 11.
My lords, item 11, I appear with my senior my lords for the petitioner. On the last date, on 4th of January, my lords, I had appeared. I had sought for withdrawal of the writ petition, my lords. Your lordships were pleased to allow it. However, my lords, what has come to our notice is that there was a certain deposit of to the tune of 3.63 crores that was made towards penalty, my lords. Now, my lords, what has happened is this demand, the original demand, I have challenged in a separate writ petition 8662 of 2019. However, this deposit of penalty has not been challenged in that writ petition and needs to be adjudicated in this writ petition on merits, my lords. If your lordships.
You are agreeable.
No.
Huh.
I'm not agreeable.
Huh.
The number is WPC 8662 of 2000 is in another case.
No. He's saying in this petition, he wants to argue the question of penalty.
No.
No means what? You want to challenge the application.
I'll file the contract with this IA.
All right. Notice, he accepts notice. Reply be filed within.
Lordship, may I submit, my lord? This writ petition that we are seeking recall of deals with an entirely new subject. It is dealing with.
Let him examine it, sir. Without knowing, he'll simply agree to what you're saying. You can't expect that.
Today I received it.
Let him file a reply. Reply be filed within 6 weeks. List on 18th August.
Item number 12.
Obliged.
May it please your lordship. Your lordship have filed an IA for modification, which is a flag X of your lordship's brief. Now, my lord, this is a case, my lord, if your lordship remembers about this trade certificate matter, which was disposed of in December last year, my lord. the trade certificate section 5, my lord.
Yes.
My lord, I've filed an IA for modification, my lord. My lord, what has happened in the meantime is, my lord, if your lordship remembers, your lordship's judgment relevant is para 55, page 48. Your lordship had categorically said that they cannot demand on the basis of the.
But you file a contempt, sir, not an IA.
I completely bow down, my lord. My lord, if I may be given an indulgence for 2 minutes, my lord. If your lordship says I will go and file a contempt, my lord. My lord,
Yes.
the fact of the matter is, my lord, there are 37 RTOs and hundreds of my lord, dealers. I only wanted, my lord, because my lord, I have taken a specific contention. What they're saying is, they're saying we are not aware of this judgment, even if we have submitting certified copies, my lord. If the STA, my lord, is directed to circulate it to all the RTOs, my lord, then multiplicity of suits will reduce. Otherwise, my lord, I will have to file contempt. I bow down, my lord. But my lord, I only pray if your lordship indulges.
Lord, all the RTOs has been intimated, not only by the Office of the Transport Commissioner, through court, my lord. The judgment has been delivered to all RTOs.
Counsel for the Transport Authority insists that copies of the judgment has been circulated to all the regional transport authorities. Although counsel for the petitioner contests this paragraph, if despite the above, there is any non-implementation of the directions contained in the judgment, it will be open to the applicants to seek other appropriate remedies available to them in accordance with law. All right.
Lord, I've already filed one which is in contempt, but I'll do so, man. I completely bow down.
The application.
Grateful, man.
Right. Item number 13.
Here, I have filed the application for modification of the header on the ground
Item 13, lordship. I am applicant, lordship. I pray just day before yesterday the IA copy was served, lordship. I pray 7 days time to file the reply to the IA, lordship.
Then, my lord,
I am for the appellant writ appeal, lordship.
My lord, then, my lord, the operation of the order may be stayed, my lord, by suppressing entire fact, my lord. My lord, they have not moved before the Honorable Appeals Court against this order, but annex that order as.
No, but where is question of stay? I don't understand.
My lord, your lordship has remanded the matter to the appellate authority.
No, we have not. Single judge had.
No, single judge has quashed that proceeding.
No.
Yes, my lord. Your lordship will carry the certified copy is with me.
This matter, lordship, the single judge was
Yeah,
placed to
single
pass
judge
the
has
proceeding. The present appellant challenged it before the Honorable Appeals Court, and the Honorable Appeals Court remanded the matter to this Honorable Court and directed him to file inter-appeal. Accordingly, the present appellant filed this writ appeal, and your lordships, after hearing the matter, your lordship, they remanded the matter to the suppletor, and in view of the order passed by your lordships, the suppletor has already issued notice to the party, your lordship, and the matter is sub judice before the suppletor.
Against this order, they have not moved before the Honorable Appeals Court.
All right, you just say notice, he accepts notice. Reply be filed within 4 weeks, was joined over for the next date. The order dated 28/2/2023 shall be kept in abeyance till the next date. All right. List on 11th August. Right.
11th.
For judgment, W number 467 of 2010 and 468 of 2010.
Both the appeals are allowed, and we've quashed the orders dated 7 January 78 of the additional Tahsildar and the consequential orders 24th February 2004 by the Joint Commissioner and the single judge's order. We've said that if the present occupants of the plots in question do not hand over vacant and peaceful possession thereof on or before 1st July, it will be open to the CMC to take possession thereof in accordance with law.
For delivery of orders, WPC 10687 of 2016.
The writ petition is dismissed, the interim order is vacated.
WPC 2803 of 2018.
Here again, the writ petition is dismissed.
WPC 8031 of 2019.
This writ petition is dismissed.
WPC number 3697 of 2021.
This is also dismissed.